He's still in jail, huh?
Yes, she's still in the county jail. Okay. Good afternoon, everybody. Just 1 second here, please. We are already live on YouTube. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, August 9th, 2023 at 1:34 p.m. And this is 2019-2435 DC. Talissa McCoy versus Joshua Brown, attorney Teresa Reiser for defendant.
Okay. Good afternoon to everyone. We are appearing virtually, and I want you to know this is a court proceeding, and you need to conduct yourself as if you were personally in court. Appears that we have good connections, so that's not a problem. I will tell you, everyone will have an opportunity and have multiple opportunities to speak, so do not interrupt each other, other witnesses, and especially do not interrupt me in this matter. If you do have, do not make comments when someone else is speaking or testifying. You'll be given an opportunity to respond. If either party, if any of the parties engage in offensive conduct, interrupt the court proceeding, you could be held in contempt of court and go to jail. So just govern yourself accordingly. Ms. Reiser, your client has filed the motion in this particular matter. Do you wish to make an opening statement or proceed to proofs?
I can proceed right to proofs, Your Honor.
Okay. Ms. McCoy, you have an opportunity to make an opening statement, or you can reserve the opening statement or waive opening statement. Do you have any opening statement, or are you not?
No, sir.
Okay. Okay. Ms. Reiser, you can proceed.
Did you want to swear Mr. Brown in?
Yep. Mr. Brown, if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Go ahead, Ms. Reiser, when you're ready.
So, Mr. Brown, I'm going to ask you a series of questions. If at any time you can't hear me or you don't understand the question, just ask me to repeat it, okay? Or if you can't hear or understand the judge, just ask us to repeat it.
Yes, ma'am.
Mr. Brown, you were never married to Miss McCoy, correct?
Correct.
When approximately were you in a relationship with her?
Approximately 2015 to approximately end of 2019.
Did you believe your relationship was monogamous?
I did, yes, ma'am.
And did Miss McCoy have a child during the time that you were together?
She did, yes.
Do you know approximately when that child was born?
Approximately August 2018.
Okay. And did you believe you were the biological father to that child?
I did, yes.
And why did you believe that?
Because we were in a relationship when the child was conceived and actually when the child was born.
Okay. Because you believed you were the biological father of that child, did you sign an acknowledgement of paternity acknowledging that you were the child's father?
I believe I did, yes.
And is your name on the child's birth certificate?
It is.
And were you ever ordered to pay child support for that child?
Yes, ma'am.
And approximately, if you know, when did you start paying child support?
It had to have been November 2020 when I started working at Prairie Farms.
Okay. Did you ever exercise parenting time with the child?
I did.
For approximately how long?
That would have been when the child was first born in 2018 and early 2019.
Okay. Did you later learn that you may not be the biological father of that child?
I did in the end of 2020, I found out.
Okay. And how did you learn that you may not be the child's biological father?
So I was incarcerated the year 2020. And during that time, my father and mother they went to an attorney and they asked to get grandparent rights if there were to be that, from what I understand from my parents, because they were having a hard time contacting Talisa to see Ewan at times. So the attorney that they went and seen, they said, well, first you have to go take a DNA test. So when we do go to court, we have something to stand on. So they went and they did the paternity test or DNA test, and they came back that it was less than 1% chance that they were the grandparents. That's actually when I got out of jail. That's how my dad waited till I got out of jail to tell me that information. And so that's how I found out he wasn't going to be mine.
And what did you do when you learned that you may not be the biological father?
The first thing I did was my dad paid for a consultation fee with an attorney, Cindy Thomas, and she told me to sever all ties with the child immediately, which it was a year. It was already a year I hadn't seen him. I was in jail. Furthermore, I didn't see him or have any communication with him anymore from then on, based on her counsel.
Okay. And did you ever take a DNA test?
I did. I took my own test. So that was 2020 when I did that.
Okay. And what were the results of the DNA test?
That test said it was negative, that it was a 0% chance that I was the father of Ewan.
And then you submitted to a second DNA test at the order of this court, correct?
Correct.
And what were the results of that DNA test?
Also, that one said there was a 0% chance that I was the father.
Okay. And after you learned that you weren't the child's biological father the first time, did you said you cut off all ties? You ceased exercising parenting time?
I did. They were already. I hadn't seen him because I was in jail, but I did. I had no more. I exercised no more parenting time with him from then on.
And so, when was the last time you had contact with the child?
That would have been 2019, around October 2019.
And approximately how old was the child at that time?
He had to have been 1 at the time.
And do you know how old he is now?
He has to be 5 now.
Okay. So do you believe it would be a fair statement that say you had a relationship with the child for only maybe a year, very early on in his life?
Yes, ma'am.
And do you believe the child is bonded with you?
No.
Do you have any sort of relationship at all?
Not at all.
Do you believe any type of harm could come to the child by revoking your paternity?
No, not even the support that I provide to Lisa, because she does. We neither one of us have legal guardianship of him anymore.
Okay. So, Your Honor, it's clear that no harm will come to the child if Mr. Brown's paternity is revoked. It's not against the child's best interest to revoke his paternity because the child most likely doesn't even know him. So Mr. Brown requests that his paternity be revoked, that the order of affiliation be set aside, that the uniform child support order be terminated back to the date of the filing of this motion, and that the parties take the necessary steps to remove his name from the child's birth certificate.
Okay. Ms. McCoy, you have an opportunity to question Mr. Brown if you wish to do so. Do you have any questions for Mr. Brown?
No, I know the whole point of this court date is to get, to terminate his child support order. So I just leave everything as is, and that's okay.
Okay.
And Your Honor, we did provide a proposed order, I believe, to the court on July 19th.
Okay. Any other witnesses, Ms. Reiser?
No, Your Honor.
Ms. McCoy, do you wish to testify?
No, sir. Regardless of what was said, my argument it doesn't matter. You know what I mean? He deserves to not pay child support anymore.
Okay. Okay, hold on one second. Court will note that the court has heard the testimony today by Mr. Brown in this matter. Court will note that I will, in fact, take that testimony as well as the defendant's verified motion to revoke paternity, set aside order of affiliation, and to terminate uniform child support order that was filed in this matter previously. That has some additional information that was not testified to today, but it is verified, and the court will consider that. Court will note as well that the mother, Ms. McCoy, is present as well. She has not offered any testimony at this time. It has not offered any testimony to refute or dispute any of the testimony of the defendant. Court notes, Ms. Reiser, I guess I'll ask, you haven't, but do you seek to have the DNA test report admitted as an exhibit?
Yes, Your Honor, please.
Okay. We'll have that submitted as defendant's exhibit A, as there was no other exhibits. I know attached to your motion, you had it marked as defendant's exhibit B, but we have no more in this hearing, so we'll utilize that as A. Well, in this matter, it's very clear that, again, the parties were engaged in a sexual relation at the time of conception and at the time of birth of the child. However, during the defendant's incarceration, his parents pursued a DNA test, came back at, he said, less than 1% probability of paternity. He was incarcerated at the time. He was not informed of that, he said, until such time as he was released from incarceration, which would have been sometime in 2020. He then proceeded to get a DNA test, which in fact determined that he was a zero probability of paternity. He then subsequent, as a result of these proceedings, had a second test, and that test has been admitted as defendant's exhibit A. It's a DNA test report from DNA Diagnostic Center, dated 6/21/2023 by Deputy Kumar, PhD, and attesting to the fact that the test was of the defendant and the child in this matter, who was, I would just refer to by initials, he's EAB, date of birth, August 4, 2018. And that shows a probability of paternity of 0%. Court notes that the court then does have to look at and determine whether it's in the best interest of the child to revoke paternity, or in this case, the acknowledgement of paternity. Court notes in looking at the factors, first, whether the presumed father is stopped from denying parentage because of his conduct. The court will note that the court has not heard any evidence which would have stopped him from denying, again, parentage. He believed, based upon representations of the plaintiff, that he was, and only found out subsequently when he was incarcerated, or actually after he was incarcerated. He then took action at that point to have a test done. He also severed any relationship he had with the child. He only had a relationship for probably a year or less, and the child is 5 years old now. And as a result, the court doesn't find any issues as it relates to that. Next factor is the length of time the presumed father was on notice that he might not be the child's father. That again occurred in 2020 when he pursued the test results, and then subsequently in these proceedings. The facts surrounding the presumed father's discovery that he might not be the child's father, we've already addressed that. Next, the nature of the relationship between the child and the presumed father. In this matter, we've testified they had a relationship for a year or less. And again, the child is now 5 years of age. Next is the harm that may result to the child. Obviously, there's been no relationship for almost 4 years over 4 years at this point. So the court will determine that, again, there's no harm in this particular matter. Other factors that may affect the equity arising from the disruption. Again, court does not find that there is a father-child relationship, so there would not be any problem with the equities arising from the disruption, and any other factors determined to be appropriate. Court takes into account all of the testimony that was presented in this matter, as well as in the verified motion. In this particular case, when the court does, the court will determine that the there's not issue of the defendant in this particular matter, that the child is a child born out of wedlock, and the court will grant the petition in this matter to revoke the acknowledgement of paternity in this matter. Also to set aside the order of filiation previously entered, and to terminate the support obligation that the defendant has had in this matter since some time back in this case. With that, the court will enter the appropriate orders. Ms. Reiser, is there anything else that you believe the court needs to address or has not addressed before we conclude?
No, Your Honor, I just have one question. Is it sufficient to provide a copy of your order to the friend of the court, or do we need to do a new uniform child support order?
No, you should be able to. This one will terminate that. You
Okay.
should be able simply to provide them with a copy of it. I guess if they are requesting something else, that you could pursue it at that point, but I would think that it obviously is a court order, that they would comply with that and recognize the court order.
Okay, thank you.
Ms. McCoy, is there anything you believe the court needs to address or have not addressed before we conclude?
I know that you had mentioned it. I don't know if it's required or whatever, but my mom had done a DNA test on the actual biological father, but he passed away. So I know that it doesn't matter. It doesn't have anything to do with, terminating Josh's parental
Correct.
order or none of that. But I just wanted to let you know that in case that was, a question that
Okay.
popped up, like,
Well, the only thing that might be is obviously if he's deceased, it may be of importance to you, because if you can establish paternity on that individual, the child may be entitled to various benefits as it relates to that individual.
yes.
Court will note too, thank you brought that up, that your mother, the court would note that the plaintiff's mother is currently the guardian of the minor child, and pursuant to order of the court will note that she did file an answer to the petition this matter, where she did not dispute nor contest these proceedings. So I just wanted to mention that on the record as well. So that will conclude this matter. We'll end at 1:30.